Hi, I'm Joyce Brafford. I'm an estate planning attorney in North Carolina, and today we are going to talk about part of estate planning that almost no one explains clearly: funding your revocable living trust. Here's the truth. You can sign a beautiful trust, you can put it in a binder, and still end up in probate if the trust isn't funded. So today, I'm going to walk you through this step by step in plain English. No legal jargon, no panic, just what this actually means and what you need to do. As a quick note, this video is meant to serve general educational information to you. While I am an attorney, I am not your attorney, although I'll be happy to help if you live in the state of North Carolina. For specific advice about your estate planning needs, please contact an estate planning attorney in your jurisdiction. Before we talk about funding a revocable living trust, I just want to take a minute to explain the difference between a will and a trust, because this is where a lot of confusion starts. A will is a set of instructions that becomes effective only after you die. It tells the court who should receive your property, who should serve as executor, and who should care for minor children. A will almost always requires probate, which is a court process. A revocable living trust, on the other hand, is effective while you are alive. It allows your assets to be managed during your lifetime, during incapacity, and after death, often without those assets needing to be probated. There may still be a minor probate process, but your major assets can be protected in your revocable living trust. A trust is especially helpful for some people, but it's not required for everyone. Let's think about a few scenarios to see if a trust might be the best option for you. First, do you own property in more than one state? Without a trust, your family may have to go through probate in each state where the property is located. A trust can often avoid that. Second, if there's a likelihood of disputes in probate, trust administration is generally more private and structured, which can reduce conflict, court delays, and even court involvement. And third, if privacy matters to you, probate is a public process. A trust allows most details of your assets and your distributions to remain private. And fourth, if you want continuity and simplicity, if something happens to you, a trust allows someone you choose to step in and manage things without court appointment. Okay, important clarification about taxes, and this really matters. I want to clear up a very common misconception. A revocable living trust is not a magic way to avoid property taxes forever. In most cases, a revocable living trust functions as a tax deferment and management tool and not a tax elimination tool. What that means: property can often be used, accessed, or lived in by your descendants without immediate transfer of legal ownership. But property taxes are typically paid when that property is legally transferred to another person. And property taxes here, I mean your capital gains taxes. You will still have to pay actual property taxes, or the trust will pay property taxes annually. You cannot get away from that. So while a trust may delay certain tax consequences and provide flexibility, it does not mean your children or grandchildren will never pay property taxes, and that distinction is really important. Once you decide that a trust makes sense for your situation, the next and most important step is making sure it's actually funded. So now let's talk about what funding a revocable trust really means and how to do it step by step. All right, what does funding the trust really mean? First, let's clear up the phrase funding the trust, because it sounds intimidating. Funding your trust simply means this: making sure your assets are either owned by the trust or have beneficiaries named correctly. That's it. If an asset is still in your individual name with no beneficiary, it may still go through probate even if you have a trust established. Let's start with bank accounts. Checking, savings, and money market accounts. These are usually the first things we move into the trust. What you do is contact your bank and tell them you want to retitle your account into the trust. They'll usually ask for your ID and a certificate of trust. The account will then be owned by you as a trustee of your trust in most cases. From your day-to-day life, nothing really changes. You still write checks, you still use your debit card, the money is still yours and you have access to it. It's just owned in a way that avoids probate. Next, real estate. This includes your home, rental property, or land. This is one of the most important assets to fund into a trust. Funding real estate means preparing a new deed that transfers ownership from you individually to you as trustee of your trust, and then recording that deed with the county. This doesn't mean you lose control. your mortgage changes, or you can't sell or refinance. It simply changes how the property is titled. This step should be handled or reviewed by an attorney because state laws matter here. Now let's talk about non-retirement investment accounts, like brokerage accounts or taxable investment accounts. These are commonly owned by trusts. You'll contact your investment company, complete their trust paperwork, and provide a certificate of trust that's part of your trust packet. Once again, you are still in control. You're just holding the account as the trustee. Retirement accounts are different. Your 401k, IRA, or Roth IRA should not be retitled into your trust. Instead, what matters here is your beneficiary designation. Sometimes the trust is the beneficiary, sometimes a person is. This depends on your family situation, tax planning, and whether or not you have minor children. The key takeaway is this: retirement accounts avoid probate through beneficiaries, not trust ownership. Life insurance works the same way. Most of the time, you don't retitle a life insurance policy into a trust. You review and update the beneficiary instead. This is especially important if you have young children because the trust can manage the money for them if something happens to you. People always ask about cars. In many cases, vehicles stay in your individual name. Some states allow trust ownership, others make it more trouble than it's worth. This is one of those areas where you should ask before doing anything because the goal is simplicity and not extra paperwork. Personal property. This is your everyday stuff. Furniture, clothes, kitchen items. These usually don't require individual retitling. Most trusts include a general assignment of personal property that sweeps these items into the trust automatically. So unless something is extremely valuable or titled separately, this part is usually already handled. The step that most people forget, and the one that's most important, is the beneficiary review. You should review beneficiaries on your retirement accounts, your life insurance, and payable on death accounts. Make sure your names are correct, old beneficiaries are removed, and everything aligns with your trust plan. Beneficiary designations will override your will and your trust. Here's your final gut check. Ask yourself, is my home in the trust? Is my main bank account in the trust? Are my beneficiaries updated? If yes, you're doing great. You do not have to fund everything at once. Even funding one or two major assets can make a huge difference to your family. The goal here is peace of mind and not perfection. If this video was helpful, please like and subscribe. And if you're feeling overwhelmed or unsure about where to start, that's normal. This is exactly what an estate planning attorney can help with. If you're local to North Carolina and want help reviewing or funding your trust, you can start by clicking the link below. Thanks for spending time with me, and I'll see you in the next video. Remember, this is Joyce Brafford at the Joyce Brafford Law Firm. We're protecting your family. Just takes a little planning.